Okay, Good morning, Mr. Miller.
Good morning, Judge. Your Honor.
Please stand.
Yeah, clearly.
Clearly. And you're in court, clearly, right?
Well, yes, but I'm also,
I understand that, but please remove your hat.
Oh, sorry.
Okay. Counsel, introduce yourself to Mr. Miller.
Good morning. To unmute your device, sir.
Good morning.
Good morning. Are you Mr. Byram?
Yes, sir.
Is there a reason why you don't have clothing on?
I'm actually in bed because I've been trying to heal from having emergency surgery.
Okay. All right. Well, future reference for future purposes, you want to be sure and make sure you're dressed for court appearances. Okay.
Okay.
All right. Thank you.
Make sure you're
All
on.
right.
Okay. Hi.
Judge, I'm here on an off-docket matter to turn my client in. I approached you on Zoom some while ago, and he has two bonds. The bond was forfeited, Judge. Case number 253-1349. He's out.
Okay. I have some thank yous to make here. Brecken, Alyssa, Kurt with Chrissy, Shelly K, Zach, and I poached one from. I can't remember. Lucid's Lair? Is that it? Whatever. Link to it in the description. I also have something fun. Let me see here. I think it's too long to play now. But let me look up so I know the title. I've got a fresh soft sit song called Just a Sovereign Idiot. I think I'll play it at the end of the stream so we can let it go. All right, let's carry on, shall we? Here we are in Judge Fleischer's courtroom, obviously, and Soft Sit shows up. Thankfully, he's represented.
Side, can I go get him, or you want me to wait?
Please. Mr. Daly?
Yes, sir.
All right, please. Greg, talk to me.
Hey, Judge. So I'm on Alejandro Kevin Martinez. It's the same person, but one of his cases has him listed as Alejandro Martinez, the other three Kevin Martinez. So he was in custody. He's got a felony pending. He made bond on all his cases.
Okay. Where is he?
I don't know. I haven't heard from him. I would hope if he made bond.
He's here. Greg. All right. Do you mind? Come on up. Let me do this real quick, Greg.
Yeah, I'll get back on standby, Judge.
Gotcha. It's up to you.
All right. Good morning, Mr. Daly. What would you like?
So, Judge, two things. I've talked to Madam Prosecutor on this case, Judge, and I'm approaching on two things. One, bond reinstatement and PC on this case, Judge. She and I have already discussed it on this case, and we just both want you to hear the PC if we can, Judge.
Okay.
And then on the bond reinstatement as well, Judge. Right.
So officers initiated a traffic stop in Harris County, Texas for a vehicle having a fictitious plate bearing the word traveler on it. During the stop, the defendant refused to provide...
Traveler? Okay.
During the stop, the defendant refused to provide ID or insurance information, stating, "I do not consent to this." Officer attempted to remove the defendant from the vehicle, and defendant actively resisted by pulling his arm away from deputies until he was detained.
Okay. Tell me what.
So we looked at, Madam Prosecutor, the interference with duties of public servant, Your Honor. Even if my client is failing to give them that, then it is an arrestable offense. But in this situation, it is, Judge. However, in this particular situation, he didn't interfere with anything in terms of his own arrest. I can, if it was a resisting or something to that effect, I can.
They're just trying to get him out of the car.
I don't disagree.
It's classic sovereign case where got the license plate, think that traveling by right is what I think how they term it.
In this situation, Judge, and the reason I'm employing upon the court is, even from what Madam Prosecutor has seen on the video, they're pulling and tugging at his arm, which put my client in some fear. It was more than one officer. It was pretty.
But he still has a duty. If they're asking you to come out, they can lawfully do that. And there are videos, and go on YouTube, right? There are hundreds of videos where officers will literally destroy your car to get you out. When you get into a pissing match with a person who has the power of arrest, who's going to win, Mr. Daly?
We don't disagree, Your Honor.
Right.
That's
You know
not,
what I mean? That's real life.
we don't disagree, Your Honor. I think under the circumstances of what actually happened, it was not Mr. Daly's position to resist or to interfere. That was not. He was concerned for his safety at that point. And actually, I don't know. Did you hear that on the video?
Yeah, that is awkward. I don't know why she's touching him the whole time. I think she's trying to sort of be motherly. I don't know. It's subconscious. But it sends the clear signal that, yes, I know my client's a simpleton. She doesn't, I don't think she's consciously trying to do that, but that's what she's doing.
Right. And so in reviewing the video, it was pretty quick, pretty brash. They didn't give him an opportunity to respond per the prosecutor in this situation. It wasn't as if he was intentionally
Remember,
not.
this is just a mere probable cause.
Yes,
So,
Your Honor, I agree.
they ask you to come out of the car one time. Yeah, it's really, that's, so, I think that there's enough probable cause to go forward now. The problem is, Mr. Daly, is that we revoke your bond is set at 2501, and you've continually failed to appear. So, the case and the way that you've treated us, it shows me that you just refuse to accept authority. How are we supposed to deal with that?
Seriously? Is she her client's mother? Or are you just saying that? That's interesting.
How do we deal with that, Timro?
Your Honor, the only reason I bring to your attention is I asked the court to take into consideration, we have a Black male works every day who, and I hate to put that on the court, but I do in this particular climate, that has never been in contact with any particular law enforcement court system. And from what I can see and what I hear out here from a lot of my Black male, and I'm sure it's common knowledge, is that because they are unfamiliar with the court system, they don't know, number one. Number two, when they do
Naughty, Maria, naughty.
come in contact with police, and my mother is assistant chief of police. So I can understand, even when I was younger, I was taught that there are certain things that you have to do with a police.
This happens, and it happens every day. I don't mean to pick on this attorney. They do it because it's effective, but it is so incredibly racist and offensive. My client can't appreciate basic facts of life because of his color. It's so insulting. It's unbelievable, but it won't go away. It's done every day because sometimes it works, and this is the type of judge it would work in front of.
When a police officer even stop you on a speeding ticket. What we don't know is whenever these officers come up, when you're somebody who don't have the privilege of having a, police officer as a parent, or who isn't familiar and is being raised in this particular climate, and seeing what they see on TV and seeing what they hear and everything that has occurred, you don't know what the proper steps are. I was trained from when I was grown up what you do. I'm not saying that what he did was right or wrong. I'm not saying that how he reacted to this particular court, it is wrong. However, I'm employing upon the court to ask the court to take into a little bit of consideration. Number one, from his perspective, all defendants, can't just say this, but I do see that, from what I've known from this particular case and now in talking to him, I do believe that there is a sense of sometimes they just don't know. Sometimes they just don't. So I'm asking to reinstate his PR bond. I am now on the case where about me. I'm a tight attorney. I run a tight ship. So, and by which of way I believe I can reach him and getting him to court and resolving this matter, which is what I talked to the prosecutor about when you were on break. It's like, let's just resolve this. Let's take care of this.
I'll buy it.
Yes, sir.
Okay.
Thank you, Judge.
I'm not going to do this again, though. I promise you.
See, it worked. There you go. And good. I agree, Barry. She's full of it. I think she knows she's full of it. This isn't like a philosophical thing. This is advocacy for her client. She's doing a good job. So that's why I said it. Yeah, you know, it's insulting, but in the moment, it will help your client at least 50% of the time, if not more.
I don't care whoever you have. If you flake on us again, that's 3 times. It's out. I'm not going to do it again. Do you understand, Mr. Daly? I mean, when you come to court, good things happen. When you don't show up and you continually do it, you can't expect good things to happen. Now, do you have a Texas driver's license?
No, it's right now.
You're not allowed to drive.
Right.
She is, and she did.
You have a bond condition and you've signed an affidavit with me today promising you're not going to drive. I don't care how you term it. Driving, traveling, however you're going to word it, whatever you do not get into the driver's seat of an automobile, a motorcycle, anything with a combustible engine where you can get on the road unless you have approval from us. Do you understand? I don't care that you have to work. I don't care if you have to go to church. I don't care if you're going to a funeral. I don't care if you're going to wherever it may be. Do not drive. Do you understand? Heed this warning. You're not going to get another one. Okay, Timberlake, I'll
you.
reinstate the bond.
Thank you, Your Honor. And I'll talk to her. We were going to try to talk to Chief, but it's pretty busy
I
today.
think the case is only 3 months old,
Yes,
so you've got time. You can do whatever you want.
Yes, sir. Thank you, Judge.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court now, but you must stay in touch with her and she'll tell you when you got to come back to court. If she comes back and tells me she can't get a hold of you because you're playing games or you've gone AWOL.
He's going to be playing games. Why wouldn't he? He doesn't show up to court or whatever, and then you show up. This attorney shows up with this sham, and he gets away with it. He has zero respect for the court.
Whatnot, or you get arrested for something else, all bets off. We good? I'm not asking for much, man. You know, really. And for future reference, when you get into a pissing match with someone with the power of arrest, you are nearly always going to lose. It's just the way it works. And as a young black man in today's society, you got to be extra special careful because things can go really wrong.
Okay, I want to puke. Knock this crap off. Knock this crap off. Perpetuating this. Insulting an entire class of people. Ugh.
Really quick. And there's evidence of that over and over and over. Okay? All right. Good luck, guys.
Thank you, Your Honor.
Yes, ma'am.
Thank you, Judge. Go ahead. Thank you. Thank you. You want to show this to Chief?
Yeah, I just sent her.
Thank you.
Yeah, of course.
No. Soon. I got to get Greg because he's been waiting for a long time. Greg.
That's called the case of the people state of Michigan versus Daniel Magoo.
Your Honor, after Lonnie, but people.
Good afternoon, Your Honor. Daniel Magoo. All right.
I think Daniel Magoo should try the driving while white on Judge Simpson. Let's see how that flies.
Mr. Magoo, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth. And
A smart man.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed.
What are we contemplating here? January 2nd? That would be good. And I need some hot content to start the new year. Let's do this.
A writ of mandamus with the Court of Appeals for the state of Michigan
Yes.
that was subsequently without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern.
Oh, yes.
The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that we can sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response.
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my. What I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong.
Oh, sweet Jesus. There's no exculpatory evidence. Yeah, that's the effing problem. That's why we're going to trial. He does not know what he's saying. He just said there's nothing that helps me. He didn't mean to say it, but that's what he said. Oh, good Lord.
As far as anything that they've submitted. So
He gets another one.
Not a smart man.
it was improper for the wording, Your Honor. I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense.
Boom. Beautiful. Everyone says we're going to treat them like attorneys and they're not going to baby them and whatever. And that's sort of the standard that no judge lives by. And I understand why. I'm not knocking them. But Judge Simpson's had enough with this guy, and he's done this like 10 times, and that's exactly what it is. If I said there's no exculpatory evidence, which is stupid and was non-responsive to the status of discovery, he thought it was responsive, but it's so dumb, it's not. If I said that, that's exactly what a judge would do. They say, well, you've formulated effectively no objection, carry that, we're moving on. That's that. I expect you to give me a good reason when I ask. You didn't. I'll just take it as nothing.
As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
With it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Yeah, we kick this whole thing off. We're set for trial January 2nd. He doesn't know that you need to do a notice of motion. All this stuff is important because that's how things get done. Okay? It's not just technical stuff. There's reasons why these things happen, but I like it. His approach today is I'm going to go work on my notice of motion. Notice usually requires a week or two. We're into December. There are a few holidays at the end of the month, and he's set for trial on the 2nd. But he's just now rubbing his chin about his notice of motion on his bullshit motion that's going nowhere. It's so good.
Thank you, Your Honor.
And continue.
Okay, to this gentleman on the iPhone, kind of a green t-shirt, glasses.
Oh, this guy's not a soft sit, but he's, good Lord. You'll see. It's Alyssa's fault.
Not looking at me. Sir. Hi. I just sent you a prompt on mute. Hi, presumably your name is not iPhone. Can you tell me your name, please?
Cornelius, no.
You said last name Smith?
Yes, ma'am.
It's the very last case, Your Honor.
Cornelius Smith. Okay. 24C6595. This is 922 Homes LLC versus Michael. Sorry, this does not happen frequently. Can you put me out the ROA 46596?
Yeah.
Okay. Let me try that again. 24C6596. This is 922 Homes LLC versus Cornelius Smith.
Good morning, Your Honor. David Fantera on behalf of the plaintiff. The current balance on this case, including court costs, is $2,665. I also want to point out that I spelled his name correctly on the summons and complaint, but the court changed it because it is actually not Cornelius. It is actually Cornelius. I spelled it right on the summons and complaint, but the court changed it.
Okay, I will make a note so that the court fixes that. Apologies. Can you send them a note about that? Yeah. Okay, thank you.
Oh, yes. Cornelius. And he acts just like you would suspect.
Okay, Mr. Smith, do you have any questions about that advice of rights presentation?
No, ma'am.
Okay.
But I do want to say something, though. Just briefly, real quick.
Okay. Pertaining to what?
Yes, talked to the property manager. I told her when I get paid, which I got paid today. I told her I was going to pay November and December rent. I said, don't take me to court. They still took me to court. So that's a problem with them. I don't mind paying November, December rent, but I'm not paying no court.
That's the problem with these people. They take me to court when I don't pay my rent. His premise is that I didn't pay my rent. I've breached my lease. And I told him I wasn't going to pay him if they took me to court. Well, that's not how it works, my man.
Fees for the property manager so that I can put extra money in their pocket. It's Christmas coming up, everything high. I threw my TV out, my couches out just today because so many roaches. Now roaches crawling in my refrigerator. I'm still don't pay the rent. The problem is with them, they abusing their power. I don't care about paying the rent. The problem is they keep taking me to court. I don't want to pay no court fee. I got Christmas coming up. I want to take care of my kids and take care of my rent. I'm not trying to pay no court fees. So now the property manager is not going to pay me for all these lost TVs and furniture. I'm losing all my furniture. So who's protecting the tenants with this? Because I don't understand it. I talked to them. They say, all right, we got you. I said, I'll get paid on 11, which is today. I'm going to put my money in escrow today. I'm driving up to court to put money in escrow. I don't mind paying, but I'm not paying no court fees. I did not commit a crime. I called the office, I called the property manager. I said, do not take me to court because it's Christmas coming up. Stop trying to get extra money. The balance was $2,440. Now the balance is $2,600 on infested roach place that I'm going to have to keep cleaning. I might as well go ahead and live in the suburbs. I work at GM. I got roaches crawling in my kids' cereal and milk. I can go to the refrigerator right now and tell you roaches crawling in it. How's that fair?
Okay. So obviously that's extremely frustrating and roaches are nasty. So what I'm going to do, I'll send you an invitation to talk to the court liaison in a breakout room. Okay.
Yes,
so that she
ma'am.
can talk to you about some of your options because you may want to talk to an attorney. Okay. You're still getting the January 8th court date. All right.
I'm gonna ask you this.
Okay.
My balance was $2,440. If I pay that, which will be paid off this month. So I'm wondering, why do I have to pay $175 if I told them I was gonna pay my rent anyway?
Because what you
That's
told them doesn't matter. They have to take from a fair housing standpoint, they have to take everybody to court. They don't make money on the court costs. They don't
How
make
is
it.
y'all not? Where's the $175 going to after I'm paying $2,440?
It goes to the court, the process server, and me. So they don't make a dime. So
I'm saying, why? This is the problem. Why is I'm paying court fees if I haven't committed a crime? That's the issue with y'all companies.
Because
why y'all keep taking me to court?
First of all, you're not listening. You just keep talking. I've dealt with you before. We've had these issues before. The question you asked was, if you pay $2,440, the answer is the case will not be dismissed. You need to pay $2,665.
I don't know where the 200 something coming from. I'm not paying that. I pay November, December rent. I'm not paying that.
You need to be here on January 8th because Your Honor, can I tell him where the money goes to? It's a $55, it's a $68 filing fee, $32 for the process service fee, and $75 for me. You asked where it came from. I just told you, if you pay anything less than $2,665, you need to be here on January 8th.
Well, I'm gonna let you know when I get off the phone. I'm coming up to the court, putting my money in escrow. And also, when I get done, I'm contacting Channel 7 News, showing every video and all testimonies to every neighbor. Because these buildings shouldn't be rented out. You know that. They condemn.
Mr. Smith, last summer, you and I came to
They are
agreement
condemned.
that you could get out of your lease.
Y'all a shady company. But I'm going to pay y'all November, December rent, but I'm going to Channel 7 News, and they going to investigate y'all company. That's going to happen.
That's fine.
I'm not the one y'all going to do that to. But
as usual, they threaten to go to the media. First of all, nobody watches Channel 7 News. Nobody. More people will see this video than anything Channel 7 News does by a wide margin. Second of all, nobody said you committed a crime. You probably have, but that's not what's before us today. You breached a lease, and they're well within their rights to say, hey, you're living in our place. You owe us money. It's no more complicated than that. It's unbelievable to me.
I have no problem. I don't have no problem paying the rent. I'm going to pay it, but I'm still going to Channel 7 News. It would be paid, but y'all going to answer, why is y'all renting these apartments out? And when you got mold, you got all this stuff. These buildings shouldn't be open. And it seems like the city turned a blind eye.
I sent you an invitation. Okay. Talk to the court liaison about legal services. Thank you.
Thank you, Your Honor.
Boy, I'm just getting railroaded here.
Todd Joseph Sotheby, 24G704154. 24G704204. Your name?
Todd Joseph Sotheby.
Your name?
I think this is Alyssa's fault as well, and I have not seen it.
Michael A. Carvin, P7324, on behalf of the defendant, Your Honor.
Defendant was convicted of disorderly person. He pled to that back on June the 4th of 24. That was to be taken under 771.1. He also pled guilty on that same date to the charge of operating while visibly impaired. He's in sobriety court. I have a charge here that alleges that he violated probation, specifically by failure to refrain from consuming alcohol or drugs, testing positive for cocaine as a result of a chemical test on November 23, 24. He pled not guilty previously. Does he still wish to plead not guilty?
Apparently he does. Yes.
All right. Do we have the facility out? Okay. Let's bring them in. Okay. All right. Good morning, Ms. Walker. How are you?
The only thing I saw was the last minute, and whatever, just for my own personal reasons, I found it fantastic.
Your appearance, please.
Yes, good morning. This is Erica Walker. How are you?
Good. How are you? And your position is where?
Yes, I'm a forensic toxicologist at Redwood Toxicology Laboratory.
All right. Can you lighten that background up a little bit, please?
Yes, definitely apologize. Oh no,
that's okay.
Okay, can you
that's
see
all
me?
Right. So you're at Redwood and you're a forensic toxicologist, correct?
That's correct, sir. Your Honor.
All right. So, Ms. Tessino, I'm going to ask you to raise your right hand. I'm going to ask Ms. Walker to raise her right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
Yes, sir.
Ms. Walker?
I do. Yes, Your Honor.
Do you want to start, Ms. Tessino?
I'm sure. Ms. Walker, did you get a chance to review the test with the requisition number 313-27246?
Yes, I do have that in front of me. That's correct.
And what would be your interpretation of the results?
This is a final laboratory report that was provided by our laboratory, Redwood Toxicology Laboratory, and it was confirmed to be positive for benzoylene, which is a cocaine metabolite.
Can you verify that the sample was intact when you received it?
Yes, upon receipt to our laboratory, either through UPS or FedEx, an accessioning technician will review the specimen and make sure it's intact and the seals are and the seals match. If it wasn't, it would.
I know what she means, but it really sounds like laboratory every time to me.
Be notated under the comments part of the report, and if it wasn't intact, we would definitely call the client to let them know that the specimen was not intact or something was wrong with it.
Is it possible to be positive for anything at this level, like for something other than
hits
cocaine?
credibility a little bit.
No, ma'am, because this is a confirmed result.
I have no further questions.
Do you have any questions of her?
I do. Ms. Walker, what was the amount of the supposed cocaine metabolite detected in the specimen?
Yes, it was at 150 nanograms per milliliter.
Okay, so I guess more broadly speaking, is that what is an error rate as far as that measurement goes?
For our laboratory, as far as I've been there at Redwood Toxicology Laboratory, this is a confirmed result. There could be in a pre-screen, there can be false positives that can take place, but once you move forward and detect it, it moves forward for confirmation, and confirmation rules that out and looks for a specific drug.
Is it possible that the reading of 150 milligrams of nanograms per milliliter? I'm sorry, I'm not a chemist. I'm not good.
That's okay.
No worries.
What the judge said. Is there any potential that could be some type of incidental consumption or something like error or something that would suggest anything other than intentional type of consumption of cocaine?
No, it was just our findings was confirmed to be positive for the cocaine metabolite benzoylene. So no, sir.
So that reading, ma'am, 150 nanograms per milliliter. Is broadly speaking, is that a lot? Is that a large amount? Is that a small amount?
That can vary. How we detect anything above our cutoff is considered as detected or positive, and anything below our cutoff is considered as non-detected or negative.
And what is that cutoff value?
Our cutoff value is at 100 nanograms per milliliter.
Okay, so my client being at 150 wasn't too far over that amount, correct?
It was definitely detected above the cutoff level, sir.
Okay, thank you. That's all.
Why do you have a cutoff level? Tell the defendant.
We have laboratory criteria that's set for just for the set because different drugs have
Criterias. This is wrong. It's just wrong. I don't know what else to say. She's doing a good job overall, but learn English.
come out at different values depending on the drug. So at set levels, they are established by the laboratory criteria and the scientific community.
Do you have any other questions?
No follow-up, Your Honor.
Do you have any questions?
No, Your Honor.
All right. Does your client wish to testify?
Yes, he does.
Can you just mute or something or stay there for just a minute? It won't take long. Raise your right hand, sir. Do
No
you sound to
problem.
swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got?
Yes, sir.
Okay, go ahead.
Mr. Sotheby, did you knowingly digest the substance that the lab's technician
No,
explained
sir.
there?
I did not. No, I didn't at all.
Any type of cocaine?
Any type of cocaine.
Any type of prohibited substance under the
Any
sobriety
type of
court?
anything.
Let me finish though. Let me finish.
Okay.
Any type of prohibited substances under the sobriety court handbook?
No, sir. I did not touch anything.
Do you have any?
Oh, I want to see him try to sell this in front of Judge O'Donnell. That's not going to fly. It's not going to fly in front of Judge McNally either.
Do you have any current prescription medications?
No, sir.
None at all.
No. No.
No.
Do you have any theory as to why this detection of this substance as claimed by the lab tech would have showed up in your blood?
I assume at work, someone probably set me up. because I
What? Give
told
some
them.
details on that.
Okay, I told a worker that was selling it to one of the supervisors at work.
This is a coworker of yours?
It's a
Okay, I haven't seen it, but when he said, I think someone tried to set me up, McNally just leans back like, oh, do tell. I want to hear this.
coworker of mine.
Where do you work?
I work at Chimera International,
How long do you work there?
15 years.
Okay, and go ahead. So a coworker,
I assume a coworker probably set me up, put it in either my food, coffee, or something at work.
and what date would this have occurred on?
It'd be that Friday before I went, or Saturday morning before I went down for DNA.
About what date?
What was the date?
I believe
No.
22nd?
Question.
No, wait.
Okay.
I don't know
What
what
date is
date
that?
it
You can
was when I went down for DNA. I don't know, if it was the 23rd, and it probably happened either the 23rd or 22nd. It had to happen then.
You did testing on the 23rd?
I did testing in the morning at 6 o'clock in the morning.
That's November 23rd?
Yep,
6 a.m.
6 a.m.
At DNA?
at DNA.
And did you work the day before?
I worked during that day till 5:30, and I came right there, and then I had community service.
Okay, so
Why do you think a coworker would have gone out of their way to set you up?
I don't trust this guy.
Do you know who he is?
Yeah, I don't know really who he is, but he works there, and I caught him selling to a supervisor, so they wanted to fire them both, but it was their word against mine. But I didn't want it to go that far. But it went to HR, and then it went to this, and then supervisors, and
Mr. Sutherland, you said selling?
he was selling it right
Selling
there.
what?
Cocaine in a bag, right, like 10 feet from it.
Did you actually witness this?
I witnessed it.
How do you know it was cocaine?
It was in the bag, and it was a little white, and I was like, 5-10 feet away, you could see it.
Did you file a written report at work?
I filed one at work.
A written report?
A written report to my HR.
Do you have a copy of the written report?
I don't have it written. I can get one when I go back to work. But my supervisor went, I didn't think he was going to say nothing about it, but he went to HR, and then HR came to me, and then they found out I went to HR and told on him. So
I'm just, as an attorney, I'm thinking how this went down as he's prepping the testimony for this hearing, and I just see the attorneys saying, you know, this is going to work, right? Like we can go this route if you want to. I'll put you on there. You can say that, but the judge is not going to buy this. I want you to know that going in.
Could have lost his, 6-digit job, and the supervisor from our melt shop. He could have lost his job.
Did this employee get disciplined?
No, he didn't get nothing. Neither one of them. They just shook it off like nothing happened.
But he had reason to know that you potentially.
They knew I told because they got called in HR.
So he would have some type of incentive to, I guess, get
back at me because he knew I was on this class. I had to go drop, 2-3 times a week.
Do you recall anything when you think you ingested that substance? Did you taste anything?
Not really, but I had to go to the bathroom like 5 times that day.
Okay, so something was up.
Something was up. I knew something was up.
But you weren't sure what it was?
No.
No further questions.
Any questions of him?
I do not.
Do you have anything you want to add,
We almost got to IBS.
Ms. Walker?
Nothing I can really say because I wouldn't be able to speak until the specimen comes to our laboratory. So I'm not allowed to speak prior to that. So I wouldn't have.
I understand. All right. Thank you so much for your help. You're free to stay during argument if you want. If not, thank you so much. Have a great day.
You
Merry
as well,
Christmas.
Your Honor. You too. Thank you, everyone. Bye-bye.
Thank you.
Any argument?
No, I mean, I will say Todd has been very compliant. He was very honest with the incident that got him into the program. He didn't report any prior cocaine use. He's been attending IOP, he's attending extra, he's been going to his meeting. He hasn't missed any drops, and he seems to have a good attitude.
Any argument?
Your Honor, just that, my client has been in full compliance. I know he's the one prior violation. So for him to really, work that hard at it and come this far and then to just use cocaine out of nowhere, it just doesn't make a lot of sense. I know his explanation for it just seems, I don't know.
It makes a lot of sense. It makes a lot of sense. He wanted to do it.
Like a stretch, but I really do believe it is plausible based on our discussions. Maybe if the court has any doubt about it, we could adjourn so we can get a copy of the report that he mentioned that he filed with HR. Because
this is a leap in logic, and it's not one I'm going to buy. You're responsible for knowing what you put in your mouth. If you thought there was some kind of animosity between you and somebody else, you certainly shouldn't have left food or coffee or drink of any kind around them. I'm sorry, I'm not buying it. It's above the cutoff level. You ingested it. There's no question but that there was a cocaine metabolite in your system. I'm going to find you guilty as charged. We're adjourning the sentencing for about 2 or 3 weeks. When Mr. Carmen is here, is DNA open today?
Yeah, I gotta go today.
I want you to go today.
Yeah, I have to go today.
How many times is he testing right now? Defendant to test 3 times per week until sentence. That's a condition of your bond.
All right.
I mean, do you know what you're saying to me? Come on. If you're not kidding me, is what I'm trying to tell you nicely. I'll adjourn it. We'll set a sentence date. I'm going to give you a chance to stay clean, but he didn't really acknowledge in the beginning, by the way. I don't know if I'm buying that either. What you did at the time of this incident was reprehensible. I've told you that. I had discussions with you about it. And I'm talking about the time of this offense, not the positive test for cocaine metabolite. Lisa, what do you have for me? Or she's not there? Pardon?
Behavior in this case is disgusting.
You take the file down until, I don't
And
care.
he's here until 3 anyway.
Yeah. When's our next sobriety court going to be? Is it going to be January the
8th? Is that right? Yeah, because of the holiday.
Oh, yeah, that's right. January 25th, I'll sentence you at 1:30. How's that? Or wait a minute, you come in the morning. I'm gonna make it at,
I don't come in the morning, I come in.
oh, that's right.
I work
That's right.
2 to
That's
2.
right. That's right. We'll make it at 1:30. I can't really, the lawyers leave at 2.
Sorry, what date is it, Your Honor?
January the 8th. So you set them up for testing 3 times a week between now and then. You do have to go today.
Yeah.
Okay?
And that's 1:30?
Yes, sir.
Okay, I'll be here that day. I can-
Make sure you get that notice. Will you put a note on there for her to give him a notice before he leaves?
Okay, that's fine.
We'll see you back here then.
Just make
Thank
sure they
you.
know that. Right.
And then,
I'm disappointed in you. I'm disappointed in you. That's all I'm gonna say.
All right, we are on the record in 2024 TR
I love the disappointment ending. I really did.
617. State of Kansas versus Abel Estrada Jr. Please announce appearances.
State of Kansas appears by Assistant County Attorney Paul E. Dean.
Richard Paul on behalf of Mr. Estrada, who appears by Zoom at a separate location in council.
And how does he wish to proceed today?
Judge, I need to withdraw from this.
Okay, this is from yesterday. I think I got this from Lucid's Lair. So big shout out to Lucid's Lair. Somebody sent it to me in Discord. Thank you very much. There's so many soft sits all over the place, and I actually had to practice law this morning. I missed this one yesterday, and then they were happening this morning. It's Yesenia's fault. She made me work like almost half the day.
Case.
Your Honor, Mr. Estrada filed pro se, I do believe. Well, I know it was pro se filing.
Well, I do notice he's taken a number of filings in his own right without going through counsel. Mr. Estrada, you come back to my recollection, we've met in city court, correct?
Yes.
And now this is that tag and suspended license?
No.
No,
Just a
that's-
tag issue, Your Honor.
Just the tag, Your Honor.
All right.
I believe Mr. Paul is requesting to withdraw based upon the essentially sovereign type citizen claim filed by Mr. Abel.
Well, let me,
Mr. Estrada, excuse me.
And also, there's been a total breakdown in communications, Judge. He files his own motions. I cannot represent him.
he's, okay. All right, Mr. Estrada, you were appointed an attorney. Apparently at one point you wanted one, or maybe we gave you one and you didn't want one.
No, that's not it.
Excuse me?
I'm sorry, that's not it. He's not, Richard Paul is not seeking my interest. And I put everything in the affidavit. He's not representing me. He's actually judging me before, he's judging me before I even go into court. He's not listening to my paperwork. So he decided he doesn't want to represent me. So I still need to be represented.
Oh, smart man.
Well, Mr. Paul, you're allowed to withdraw.
Thank you.
You're welcome. Is this the last case you have on the docket?
Until 11, Judge. I have an 11, so I'm just going to mute myself and.
That'd be fine. All right. Now, I think you are going to have the same problem with any other attorney that you had with Mr. Paul. Mr. Paul, from this court's experience over the years, is a very competent, diligent attorney. Now, sometimes attorneys.
He probably is, but I think this guy's a perfect candidate for Darren Patterson. Everybody in favor of Darren Patterson. I don't think that's what happens.
Have to tell you their opinion of what's going to happen. And you may or may not agree with their opinion, but you do still want an attorney.
I do. I do need an attorney because I don't know how to defend myself with this court. And also,
I like how he says with this court, as if it's dependent on just this court. Like he's awesome in any other venue. Like federal court would be fine, circuit court would be fine. This court is the issue.
I have a thread of the communications that you can see it, and I'm not getting represented correctly. I'm sure he's a competent but attorney, but I proceeded to give all my information, all my laws, and he
All of
doesn't.
your what? Your laws?
The laws, the Constitution.
Your Honor,
So,
Your Honor, could I say
Please.
something, please? Mr. Estrada, every attorney who the court can appoint to represent you, one, I don't want to see, and I'm sure the judge is the same way, I don't want to see any kind of communication thread between yourself and Mr. Paul, because there could be confidential, well, I'm sure there's confidential and privileged information within that, and you shouldn't be disclosing that to me. That's between you and any attorney you so choose to have represent you. But I believe most attorneys, or all attorneys that the court has available to appoint to you, they are sworn to uphold the Constitution of the United States and the state of Kansas, and not what you filed. That's the attorneys didn't go to your law school, which is kind of what you've set forth. So that's the issue the court's talking about when you're claiming a sovereign citizen. We don't have an attorney who's, I guess, registered to under your rules and laws as you see them. So that's the problem you're going to be running into as far as the attorneys the court has to appoint to you. If I said that correctly, Your Honor.
thank you, Mr. Dean.
I like to say that I'm not a sovereign citizen. I'm just an American, and I'm just being constitutional, and I'm not doing anything. I'm not breaking any law.
Well, sir, you said you.
I might have to clip. I'm just being constitutional, and I might need another T-shirt.
The attorney wouldn't accept your laws or follow your laws.
No, that's not what I said. I said that,
what did you say? Because I thought you said you were trying to train him on the laws, in essence.
No, I don't. I'm just presenting the law to him, and he doesn't even.
All right, which one is it? You just said you can't represent yourself in this court because you don't know what you're doing, but yet you're going to talk down to an attorney who represents people in that court all the time. Pick a side, brother.
Read my documents that I presented, which is the law.
Did you go to law school?
No, ma'am.
He did. You know that.
Yes, I understand, but he's not being constitutional.
See, that's just one distinction. There's also the bar exam and years of practice, but you see how that could make a difference, right?
Constitutional. That's what I'm saying.
But you didn't go to law school, so are you sure you know what being constitutional involves? I mean, we all can read the Constitution and understand, yes, but there's a lot involved in interpreting that. Do you understand?
I understand what you're saying, ma'am. All I'm saying is that he's using case law, not constitutional law. And he didn't see all my paperwork. He just ignored it. He just blew through it and then gave me the wrong dates. I presented all the documents and he didn't even look at it and ignored the paperwork.
All right. And let me ask you this. You are wanting a trial on this illegal display of a license plate or failure to display, right?
Well, no, I like to.
Yes, using relevant case law. What the hell is that attorney thinking?
I like to first, if we possible, we can a motion to dismiss with a strict
We're not going to do that today. All right. I am going to one more time appoint you an attorney.
Your Honor, I would. Could I make a request to the court on this matter?
Sure.
This case carries a maximum sentence of 30 days. Doesn't even have an eligibility or requirement that he be provided an attorney.
Well,
I'm just.
There's potential jail time.
I would like to have if the court wants. I understand if the court wants to appoint an attorney. Absolutely, don't dispute that. That under the circumstance of the defense that's wanting to be presented, I would ask the court to appoint somebody. I get Mr. McClendon still available.
That's just what I was thinking. He's here in town.
We set this next hearing, give sufficient time, perhaps 60 days, perhaps longer, and we just have it set for a bench trial.
Yeah, this prosecutor is just making all sorts of sense.
And if he doesn't want to cooperate with that attorney, the state would be asking for the court to proceed to trial whether or not he can get along with the second one or not.
Well, it seems we're on the same page of thinking, council.
Mr.
Yeah.
McClendon is in the waiting room.
Mr. McClendon.
I can bring him in.
Bring him in. You're in Howard. He's got an office here in Eureka.
Mr. Estrada believes in Wichita. You're wrong.
I thought did you tell me you were in Howard?
I'm in Howard.
No, my mistake. I might have been on one of the notary stamps.
Were you in city court the night that Mr. Estrada, the gentleman under Motorola, had the tag violation?
Yes, Judge. He pointed me to his case briefly, and then
I haven't seen this part, but it's fun. He's like, yes, he's so enthused. Yeah, I was there. Oh, geez. He sees he's getting dragged back in. He wants no part of it, but he's not gonna step on Judge Webster's toes, and he shouldn't. Oh, it's fun.
Mr. Watson and I had a discussion and figured it would be more proper for a district court case.
Will you take the appointment if I give him back?
I don't have that right now, but maybe I will. Maybe I'll do that over on Vlog Talk or something later.
To you?
Because a lot of people are asking.
I guess, Judge.
All right. So you two have already met Mr. Estrada, right? The good news was he got it dismissed for you in city court, but the bad news is for you, it's back in district court. All right. So do you agree, Mr. McClendon, that we ought to just set it for bench trial, or maybe what do you
We
want
can
to
set
do?
bench trial, Judge. I'm familiar enough with the case.
Okay. He has filed some pro se motions. Okay, Missy, give me a trial date, please.
We can resolve those motions at trial, Your Honor.
Sure. I just want to let Mr. McClendon know.
How about January 3rd at 11?
January 3rd at 11. Does
I feel some denied pro se motions coming on.
that work?
Yeah, it should be fine. Do you want to do that in person, or I guess on Zoom, probably?
Well, generally we do them on Zoom. Now, if there's some special reason not to,
Okay.
I would hear the argument, but at this time I'm going to set it for Zoom.
That's fine, Judge.
All right. Thank you, Mr. McClendon. I appreciate your willingness to do that. Mr. Estrada, I will continue. You're not on bond, but I will continue the order that you reappear for bench trial January 3rd at 11. And I trust you have Mr. McClendon's contact information and he has yours from your
I
city
do.
appointment?
Yes.
You do? All right, thank you. If there's nothing further, we will be in recess on this matter and you are excused.
This is our fresh new soft sit song. All right, where are we here? All right. Thank you to Echo. There's a good taste of it. It's longer. It's all good. I listened to it. I'm gonna save it. I'm gonna play it all. I have a feeling I'm gonna have to bust that out during the trial on January 2nd, if that goes. I think it's gonna need to get played there. And probably we'll have many, many other applications. Thank you, Echo. Thank you, everybody, for sending these stuff. I got a lot of contributions. It was truly a group effort today. Good stuff. I will see you all soon.